oh yay, oh yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning and welcome to the Tennessee Court of Appeals. First of all, I want to tell you how much we appreciate you participating in this oral argument via Zoom. In these uncertain times, we believe it's the best way to continue to hear cases and move forward. On another note, though, if things progress as we believe them to be, this week will be the last oral arguments that we are utilizing Zoom in doing. So hopefully in April, we'll be back in the courtroom. Having said that, I want to remind each of the attorneys that although we are participating by Zoom, the same rules, procedures, and regulations will govern as if we were in the courtroom today. If we have any glitches, any technological problems, everybody remain calm. We'll make sure that no one's rights are prejudiced, and we'll get that fixed as soon as possible. We don't anticipate any, but who knows? Who knows what's going to happen? Before we get started, I would like to introduce our panel for this morning. We have Judge Arnold Golden from Memphis, Judge Carmen McGee from Savannah. I'm Steve Stafford from Dyersburg. Ms. Craft, anything we need to take up before we call the case?
No, sir.
You may call the case then.
Joshua Clint Hopper versus Obion County School System.
And we will hear from the appellant.
Yes, Your Honor. Good morning. My name is Chris Hayden, and may it please the court, I'm here virtually, I guess, on behalf of the defendant appellant, the Obion County School System. And now, as the court knows, this is a case about a very unfortunate accident that occurred when the plaintiff, Mr. Hopper, was a young man. Mr. Hopper suffered an injury to his eye while he was at school. And while everyone, including certainly the school, wishes to goodness this didn't happen, it did. But we submit to the court that the unfortunate thing about accidents sometimes is they occur out of nowhere with no warning and no notice, and certainly without the fault necessarily of anyone involved. We submit sometimes accidents are so unprecedented, so freakish in their nature, so unforeseeable, and so unpreventable through ordinary means that no one is at fault. We submit that's the case here. So we submit that we're not saying it's Mr. Hopper's fault, not the school system, not the teacher, not Miss Albright, the young lady that was wiggling the pencil at the time. And thus, since we submit this argument or this accident being so unpreventable through normal and reasonable means, that's the reason for our appeal to this court. And we certainly believe that our position here is supported by both the facts of this action as well as relevant case law out of multiple sections of this court. Specifically, this court, as the court knows, we're here today because we filed and this court granted our petition for interlocutory review after being denied summary judgment by the trial court in this matter. And we requested this review because we believed that the trial court incorrectly analyzed the elements of negligence that must be established by the plaintiff in this case, since it is a case founded upon a claim of negligent supervision. And we also are under the belief that the trial court did not properly apply applicable judicial precedent out of this court to the facts here. And so in supporting our position in this appeal, we turn first to those facts which we submit to the court are relatively brief. Now, as the court knows, at the time of this incident, which happened in 2007, the plaintiff was in 4th grade at an after-school program in the Obion County School System. The plaintiff was in an after-school kind of study hall classroom setting where students would go to do their homework as they waited for their parents to pick them up. And at that time, Mr. Petty was the after-school teacher in charge of that classroom. He had a desk at the back of the classroom where he testified he could see the entire classroom. However, although, as the court knows, the plaintiff makes much of the positioning of that desk and Mr. Petty's vantage point from it in this action, we submit to the court this issue to be somewhat of a red herring. We submit it's irrelevant to the court's ultimate determination in this action for 2 reasons. The first is that, as the court knows, and as we submitted in our brief in the plaintiff's deposition, he admitted that at the time of the incident, he could not testify or say where Mr. Petty even was in the classroom. He didn't know whether Mr. Petty was at his desk or somewhere else. He can't say. And so as a result, we submit that as this is a claim based upon negligent supervision, the plaintiff admitted that he cannot say with certainty whether Mr. Petty was supervising him or not. The second, of course.
Excuse me just a moment, counsel. Could Mr. Petty state with certainty where he was?
Yes, Your Honor. Mr. Petty was adamant that he was supervising that entire day and that he was able to see all the students during that day, but he could not say with certainty that he recalled when the accident occurred. No one knew that day that the accident occurred until the next day. The plaintiff didn't tell other students and didn't tell the teacher and didn't act in a way such that it notified others that the accident had occurred or its severity. The proof shows that the plaintiff just said ow when the pencil hit his eye and then went back to working on his schoolwork, and then his eye began to water, and so he got up and went to the restroom. And so it wasn't until the next day that either the teacher or any of the other students in the classroom, including Miss Albright, knew of the severity of what had taken place that day, Your Honor.
What about the testimony or I guess the evidence about Mr. Petty working on a computer in some area that I think's been described as a closet?
Yes, Your Honor. So there's been some testimony that Mr. Petty's desk was in a room, kind of a small room off the back of the main classroom. And both Mr. Petty and Miss Albright, the young lady that was actually in control of the pencil until it struck the plaintiff, testified that Mr. Petty could see the entire classroom from his vantage point from that desk. Now, I believe the plaintiff would disagree with that, but also, as I was showing to the court, the plaintiff can't say whether Mr. Petty was at his desk at that time or not. He doesn't know. And he also can't say whether supervision, as what we've discussed, since this was such a kind of a freak, unprecedented accident, whether any degree of supervision would have stopped this or not, Your Honor. So I hope
is that even relevant at this stage on a negligent supervision claim?
Is what relevant, Your Honor?
Or that the supervision would have stopped it or not?
Well, we submit that it's relevant because even if the plaintiff is able to prove that the school wasn't properly supervising, as the court said, we submit it doesn't even matter because under the court's precedent in Nicholson, in Santiago, and in Landry, some accidents such as this are so unforeseeable that no amount of supervision, absent having a crystal ball and being able to tell the future, could predict that such accidents could happen and could prevent them. So, Your Honor, yes, that's our answer to that.
Okay, well, that segues into a question that I have about the court's determination as to why summary judgment should not be granted. I've read it more than once. I'm not sure I understand it. Could you eliminate me on that, perhaps?
Well, Your Honor, you and I are somewhat alike in that. As you, of course, I've read that transcript a number of times in this action, first trying to make sense of it after it came in and deciding whether to seek appeal to this court, and then ultimately doing so, of course, and signing to that record. And certainly it seemed to us that in the last page or two that the trial court indicated that foreseeability was not necessary to hold or to decide that a school had been negligent in allowing or having an accident occur. And as the court knows by heart, one of the basic precepts of negligence is the accident has to be foreseeable, has to be reasonably foreseeable. And so that was our reading of those, I guess, last page or two. And but it is somewhat unclear, Your Honor. I will readily agree with that.
What I was looking at was the last paragraph on page 25 of what I assume to be the trial transcript. I could not quite comprehend the reasoning, and I was hoping that you could provide some light on that. Perhaps Mr. Jenkins can in his argument as well. You may proceed.
Thank you, Your Honor. So getting back, we submit that the second reason in not being able to establish that negligent supervision claim is that, again, as the plaintiff admitted in his deposition, it's potential certainly that no amount of supervision could have prevented this accident. This event was an accident that happened in a split second, completely unforeseeable, and we submit could not have been prevented through normal, reasonable, prudent means. And thus, as we were getting to, we submit the desk placement and vantage point of Mr. Petty in this action is really much ado about nothing. But moving on, depending on whom you ask, there were somewhere between 5 and 12 students in the classroom that day. And while the parties certainly disagree on some facts of the action, such as, again, the vantage point of Mr. Petty, there are a number of things that all parties agree on. All parties agree that on that afternoon, there were 2 of the students in there were Mr. Hopper, the plaintiff, and one of his friends, Miss Albright. They were both in the same grade. They were friends. They had gone through school together up to that point. They were good students. They had no disciplinary history. They never got in trouble for horseplaying. There was no negative history between them. Just in short, they were both well-behaved kids and good students. And so on that day, the testimony is that the students in the after-school classroom were working on their homework. Both the plaintiff and Miss Albright were sitting in desks next to each other, separately working on their individual homework. They were not horseplaying. No one else was in the class. There's been no proof of that. And as the court knows, Miss Albright testified that she had her pencil in her hand, and she had a habit of kind of flipping it or wiggling it in her fingers while she was thinking. And this is a point I want to be very clear on, Your Honors, as I believe it's an important distinction. And there may have been some confusion about that, potentially at the trial court or at other points in this case. There's been no testimony whatsoever that Miss Albright was throwing the pencil in the air or like catching it, or it was somehow leaving her hands. Instead, she testified that, like many of us, she simply sometimes flips or wiggles like this, her pencil between her fingers while she concentrates. And as opposing counsel would likely testify to, I readily admit that I have a number of annoying subconscious quirks that I know drive other attorneys crazy. One of those is probably doing that. And I imagine some members of the court may do that as well. I see people do this all the time when they're thinking, and they may wiggle or fidget with a pencil or a pen that's in their hands. We submit this is an ordinary activity. It's not inherently dangerous. It's not unreasonable. And while the minor was doing that, Miss Albright, she testified that somehow that pencil slipped out of her fingers and struck the plaintiff that was sitting next to her in the eye. Again, everybody agrees this was a complete accident. There's been no proof it was intentional. The plaintiff, of course, said that he had no reason to know or to think that it would be intentional. And of course, Miss Albright testified she's quite scarred by the incident, and it was in no way intentional. It was just an accident. And she wished no harm as to Mr. Hopper. And so at that time, as we talked about a little bit earlier, the plaintiff just simply said, ow. And then the proof is continued to go back to work on his homework. And then eventually got up and went to the restroom. He didn't tell anyone that he was injured that day. None of the other students knew that he was injured. He didn't tell Mr. Petty. He wasn't acting in a way that would let someone know that such a severe injury had taken place. And so no one knew until that following day, until I believe Mr. Hopper went to an eye doctor that night. And so as we've discussed, since we are here on a negligent supervision theory, it is alleged that if Mr. Petty had somehow been providing better supervision to the students, this accident wouldn't have occurred. But as we have already discussed, it's our contention that even this basic element of negligent supervision cannot be proven, namely that Mr. Petty wasn't supervising the plaintiff at the time of the incident or was doing so poorly, because the plaintiff can't say that. He doesn't know. But in contrast, Mr. Petty was able to testify conclusively that he was able to see all of the students from his vantage point, and that he did supervise the students that day, and then that is it. This accident happened 15 years ago. There are no other fact witnesses that have been taken, and so we submit right there that the plaintiff is unable to establish any sort of a deficit or really even speak to the supervision in that action. And furthermore, we point to the plaintiff's deposition in which he said that he doesn't even, or is not even able to say that any amount of supervision could potentially have stopped this, again, with it being such a freak accident. However, we would submit that as this is a negligence action, there is no foreseeability, therefore there's no duty and no causation as well. Thank you, Your Honors.
Thank you. Mr. Jenkins, we will hear from you. You're muted.
Yes, sir. Good morning. Thank you. May it please the court. I'm Lewis Jenkins. I'm here for the plaintiff, Mr. Hopper. And of course, the first thing I want to say is something I didn't write down, but after listening to Mr. Hayden's argument, I must say that unless this court intends to rewrite the summary judgment standard on a tabula rasa, there's no way that his argument carries any weight. The first matter is there is a duty to provide reasonable care by by teachers for students in every aspect of school. That has been stated, for example, in the Rathnow case. And Obion County school system acknowledged that because it had in place a policy that said it was a duty of the teachers to provide supervision for the students at all times. Now, we're talking on this summary judgment proceeding about the content of that supervision, and the content of that supervision is not actually in any measure disputed in these summary judgment proceedings. I will read from Mr. Hopper's deposition. Okay, so you're saying, Mr. Hayden asked him, okay, so you're saying that he was in the closet, that he wasn't in the classroom supervising. Is that right? Mr. Hopper said, correct. Mr. Hayden said, okay. Mr. Hopper said, because you can't see everything. You can't see the classroom from that closet. You know your vision is obstructed. And then Mr. Hayden asked him to amplify that by asking him what it's obstructed by. And he answered, because the closet is not in the center of the classroom, and plus you're back in the closet, so you've got walls and whatever other items are in the closet, plus the way the computer and the desk was facing more toward the wall. And in the middle of the closet facing out, it's facing the wall. And Ms. Albright testified that Mr. Petty was more times than not normally in that closet where Mr. Hopper said he couldn't see. I'm really surprised in a way by the content of this argument that Mr. Hayden has advanced this morning, that I don't even think at trial there's any way for them to demonstrate that Mr. Petty was providing any supervision. But I acknowledge that the burden might be on the plaintiff at trial to demonstrate that he was not. I think we've carried that burden, even if this was a post-trial provision, we've carried that burden. This man was not providing any supervision at all. And that is the end of the matter at the summary judgment stage. The rules are clear that the evidence that is put forward by the non-moving party must be believed, and all reasonable inferences from that evidence must be drawn in favor of the non-moving party. Mr. Hayden is arguing as if this testimony that I just read from Mr. Hopper and the testimony from Ms. Albright that Mr. Petty was normally in that closet doesn't exist, or that he can somehow ignore it. And that is just simply not true. The fact is, Mr. Petty provided zero supervision. Now,
does it not make any difference the effect that it might have had or not have on the injury? In other words, what occurred?
It's going to make a difference. It's going to make a difference at trial, Your Honor, but causation is a question of fact. Mr. Petty cannot say at this summary judgment stage whether or not, if he'd been there, it would have stopped it. We actually, at this point, what we know is that he was providing zero supervision. If he had been in the classroom, would he have stopped this activity? He didn't say yes or no, and we're going to have to get into that at trial. But causation, the connection between his failure and this this injury is a question of fact that remains open. He actually did not say that he would not have stopped this. I hate to admit that during this argument, because I'm sure if we go back and have a trial now, he'll probably say that at trial, even though he didn't say it in his deposition. But at this point, that doesn't matter, Your Honor. He failed in his duty, and it was his responsibility to be in that classroom watching those children. If he had been watching those children, and I think that's the explanation to Judge Stafford's question. I agree that statement is a little bit confusing. I got confused when the court told me I didn't need to be talking, which maybe I need to be told more often than that. But the fact is, the trial court was concerned about that, because the trial court said, I cannot say whether this activity would have been dangerous had he been in the room and actually witnessed it. And I think that's what the trial court meant by that statement on page 25 of the ruling in his transcript. And I think that circles back into answering your question, Judge Golden.
Mr. Jenkins, let me ask you a question, because frankly, I was confused when I was looking at this. What was the issue tried at summary judgment? And I'm going to let you answer in a minute now, but I want to explain to you my question. And that is, was it a dispute over whether supervision was being provided, or did the trial court actually have to review and determine foreseeability? Because it seems like we're talking about apples and oranges today, and in my review of what the arguments and the evidence provides. So go ahead.
Well, so I think that my reading of the summary judgment argument, Your Honor, is that it focused on the question of duty, and that duty is a question of foreseeability. And so to that extent, I think the first part of your question is, the answer to the first part of your question is that the trial court focused more on that aspect of it when when Mr. Hayden was talking about it, and then when I was responding. But I'm not sure that's the way the ruling actually came out when the trial court ruled from the bench. I think that would have been if the trial court had ruled that there was no duty and or no breach of that duty, then we would have been the ones seeking, we would have appealed that, because it was clear that at the summary judgment stage, we had established that this injury was foreseeable. In this context, Your Honor, of course, this court has said that the scope of the duty that's incumbent upon teachers to exercise reasonable care in the supervision of students is dependent upon context, is dependent upon age. And this court has said, the Supreme Court said in the Roe case, from Memphis, that it doesn't matter if the accident is a freakish one. All that matters is that the general nature of the harm is foreseeable. And so I think that although we talked a great deal about that, I don't think that's what the trial court based its ruling on. But I think if it had based its ruling on that and ruled against us, we would have been in a firm position to have that decision reversed. What ultimately I think the trial court was struggling with, Your Honor, was the question. The trial court recognized that there had been a breach of the duty. I think the trial court ultimately recognized that the duty existed and that there had been a breach of the duty. And I think, which is what I tried to say to Judge Golden, I think that ultimately the trial court was trying to articulate that there was a dispute about causation at the end, because that part where the trial judge says, I can see it both ways, looks to me like a statement about causation.
Well, I'd like to say you clarified all that, but I would be being disingenuous. So we will proceed on, but thank you.
So and ultimately, Your Honor, I'm not sure that matters. Does that help clarify it? Because I think that if
and for both of you, let me tell you where I'm trying to figure out is what issue the trial court ruled on. It seems to me that the trial court, that what was presented to the trial court was the duty question and whether that duty was breached. But it seems there are a lot of statements that really I'm having trouble attaching to that analysis. So I don't want to take up your time. Go ahead.
It's all right, Your Honor. I'm trying to go back to I was trying to get back to the actual order that denied the summary judgment. And
I've got it right here. It says summary judgment, court finds that summary judgment inappropriate in this action.
That's on page one. I got back to page 122 of the record, Your Honor.
It is.
As I said, I thought the most of the discussion in the argument was about whether or not there was a duty and whether or not there'd been a breach of that duty. But I interpreted that statement at the end of the bench ruling to be a statement about causation. And the reason that I interpreted it that way is because I don't think whether or not it's a dangerous activity is necessarily a required part of the duty analysis.
Was that issue even discussed, litigated, tried at summary judgment?
So it wasn't.
I mean, we keep talking about a bunch of stuff, but I'm just trying to define our parameters right now. Mr.
Hayden may be able to argue that, Your Honor, and I'm just turning back here to his his summary judgment papers, and on page 46 of the records, he did include a section about causation in his motion for summary judgment. But as I said, if you look at the transcript, that's not what was argued about that day that we were before the trial court. But I'm required in the exercise of candor to point out that beginning on page 46 and going over to page 47, Mr. Hayden did include a section in his memorandum of law about causation in the trial court.
Okay. Thank you.
So I do not believe I do not believe that's the basis of the ruling, or I do not believe it's what we argued about. But as the trial court circled back to it, it appears to me that may have been what the trial court was struggling with. So I guess the answer to that question is both yes and no, Your Honor. Yes, technically it was in the papers, but it wasn't what was the focus of the argument at the oral argument stage. And just in a quick recap of what I was saying, Your Honor, is that the fact of the matter is that the case law is well established, that teachers have a duty to provide reasonable care. We have demonstrated by testimony from Mr. Hopper and Ms. Albright that Mr. Petty breached that duty here. And in fact, we have demonstrated that the failure to provide any kind of supervision whatsoever, at least at the summary judgment stage, is an inference that has to be drawn in favor of the plaintiff with respect to causation. Like I said in our brief, these cases that have been cited by the appellant are cases that they seem to think are on point because they're dealing with an eye injury. And the fact of the matter is, it's not an eye injury. That matters to make the case persuasive authority in the present matter. It is a analogous set of total circumstances. And as we've pointed out, those cases fail because even though they dealt in one way or another with an eye, we acknowledge that there's a rule that when kids are playing, especially playing with toys, sometimes there may be an injury. This was not play.
Mr. Jenkins,
yes,
Mr. Jenkins, let me ask you a question here. So is it your position that foreseeability is not even relevant to this, that there's just a duty that exists, period, and there's no issue regarding foreseeability?
Well, so I think that the foreseeability question, I mean, this is a negligence case, so there has to be some question about foreseeability. I mean, I think that I'm not suggesting that the law be changed in this case. So I think that there's some aspect of this that deals with foreseeability. Yes, ma'am. I'm not saying that. It's not relevant at all.
That Judge McGee raised a question I want to make sure that I understand your response to, and that is, but did the trial court look at foreseeability? Was that part of the summary judgment analysis, or was it simply a negligent supervision, more of a factual dispute?
And I'm out of time, so am I permitted to answer
please
that?
go ahead and respond. Yes.
Yes, sir. We talked about that extensively. We briefed it both in the trial court and in our brief here. So I think that maybe what I should have said to be more precise is that I do think real foreseeability has to be discussed here, but I think we discussed it and it was resolved in favor of the plaintiff, the non-moving party in this case. So that's it. I'm not suggesting that it be taken out of the analysis, but on a proper analysis, it must be decided in favor of the plaintiff in this case.
Okay, thank you. All right, Mr. Hayden, we will hear from you in rebuttal, please, sir.
Yes, Your Honor. Foreseeability, as the court has kind of honed in on, is at the crux of this matter we would submit. As to what was presented to the trial court, our motion for summary judgment and memorandum contained almost exclusively the same arguments that we advanced to this court. All of the same things before this court in our pleadings, our appellate pleadings, were before the trial court regarding foreseeability, regarding the string of cases. And Your Honor, it's on that basis that we submit that the case law is clear. This is another in the string of the cases: Santiago, Nicholson, Landry. And in fact, Your Honor, with opposing counsel bringing up for instance, the Rathnow case, which I believe was one out of Knoxville, and also there was a Metro Nashville case cited by the plaintiff, or the plaintiff, the respondent in their briefs. Those support the school system's position. If we actually look at those cases in whole, in both the Rathnow and the Metro Nashville case, in both of those, the school was dismissed on foreseeability grounds, in the same way that the three cases, Landry, Santiago, and Nicholson, that we cite to the court, the schools were also dismissed on foreseeability grounds. We submit that jurisprudence in this state is clear, whether it's negligent supervision or any other negligence-based action, that injuries to students at school or while under the custody of the school have to be reasonably foreseeable for the school system to be held liable. And so, Your Honors, we submit that foreseeability is central to this action. It was presented to the trial court in summary judgment. While the argument seemed to maybe have gotten off the rails a little bit at the trial court, as we can all agree as to how that was addressed, that we submit that is the single most important thing in this action. Was this foreseeable? And can the school be held liable for something that's so unforeseeable that it cannot be prevented? Thank you, Your Honors.
Thank you, Mr. Hayden. Thank you, Mr. Jenkins. We appreciate your arguments. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. Again, we appreciate you participating via Zoom to get this case moving.
Thank you.
Anything we need to take up before we recess till the call of the next case?
No, sir.
All right, you may recess court to the call of the docket this afternoon.
This Honorable Court of Tennessee is now in recess.
Thank you, gentlemen. Appreciate
Thank you.
everything.
Yes, sir. Thank you.